Good afternoon, ladies and gentlemen. I'd like to welcome you to the Business and Utility Subcommittee. Today is Tuesday, March the 12th, 2024. I'd like to call this meeting to order. Mr. Clerk, can you take the roll, please?
Representatives Alexander, Burkhart, Clemens, Freeman, Hale, Holsclaw, Johnson, Marsh, Thompson, Vaughn, Vital, Zachary, Chairman.
Here.
Chairman, you have a quorum.
Thank you, Mr. Clerk. Members, before we get started today, does anyone have any personal orders? I actually do, members. We have 3 generations of Boyds out there today. So many of you have met my wife, Jada. I have my children, Wilson and Blair Ellen, who are on spring break, and all the way from Abingdon, Virginia, I have my parents, Damon and Barbara Boyd. If y'all make them feel welcome, please. Representative Thompson, you recognized.
Thank you, Mr. Speaker, Mr. Chairman. Yeah, we have visitors from my city. Erica Sugarman's County Commissioner for Shelby County. And I'm forgetting your name right now. Robert Connect, the Public Works Director for the City of Memphis. Thank you.
All right, welcome. Members, do we have any other personal orders? If not, we do have a few housekeeping items to take up. So with the request of the sponsor, item number 3, that's House Bill 1842, has been taken off notice. Item number 8, House Bill 2027 has been withdrawn by the sponsor. Item number 16, that's House Bill 0171 has been taken off of notice. Item number 17, that's House Bill 2455, has been taken off of notice. Item number 18, House Bill 2747 has been taken off of notice. Item number 26, House Bill 2874 has been taken off of notice. And item number 5, House Bill 2633 is rolled to the hill of the calendar. And item number 13, House Bill 2823 has been rolled to the hill of the calendar. Members, I think that's all of our housekeeping items. And so let's go ahead and get started. Actually, one more at the request. I just learned this a moment ago. Item number 1, House Bill 2479 has been rolled 4 spaces. All right. And we're going to go a little bit out of order, Chairman. We do have a quorum issue in another committee, so I'm going to go ahead and bring up item number 4. That's House Bill 2712 by Representative Garrett. We have a motion, we have a second, and Representative Garrett, I do see an amendment. Can you verify that drafting code, please?
Yes, could you, only one file, so I believe that's the one that we'll go with.
That's what I'm showing as well, yeah. What's the drafting code?
I don't
you
have
need
that
me
at
to
my
read, need
fingertips.
some help on it?
Yeah.
14582.
That's it.
And we have a motion, we have a second on the amendment. Do you want to explain that, or does it make the bill?
It makes the bill.
Okay, members,
Chairman,
let's go ahead and put that on the bill. We're voting to put 14582 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended. You're recognized for explanation.
Thank you, Mr. Chairman and Committee. House Bill 2712, as amended, is a small venue for music venues. And this bill was brought to me as a collaboration between the National Independent Venue Association, the Music Venue Alliance of Nashville, and the Broadway Entertainment Association. What it does, it actually defines what a live music and performance venues are under state law. It creates a potential fund, which we're not asking for any type of appropriation at this time, where we could raise money to support our small venues. It's been a backbone of Music City, et cetera, as those folks tend to perform in our small venues. So with that, Mr. Chairman, I'm ready to stand for any questions. Otherwise, I'll renew my motion.
Members, you've heard that explanation. Do we have any questions for the sponsor? If not, members, we're voting to send House Bill 2712 as amended to full commerce. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you, Mr. Chairman and Committee.
Members, we're going back to item number 2, and that is House Bill 2300 by Chairman Howell. We have a motion, we have a second, and Chairman, I show an amendment. What drafting code are you showing?
I believe I have 14186. Is that?
That's what I'm showing as well. Can I get a motion and a second? We have a motion, we have a second. Members, we are voting to put amendment drafting code 14186 on the bill. All in favor say aye. Aye. All opposed say no. The ayes have it. Sir, your bill is amended. You're recognized for explanation.
Thank you, Mr. Chairman. It's good to be in front of your committee. House Bill 2300 seeks to create a consistent
standardized across the state of Tennessee for the restoration and repair of pavement. When a street or a road is cut to install a utility or connect a house or a business to a utility such as a gas line, this bill would seek to create a standard repair of 200% above what the code cut is. For example, if they do a 5x5 square cut, that would be 25 square feet. So they would repair 200% of that, which would be, according to my math or somebody's math that gave me this, that'd be 50 square feet. So more than double of what the cut would be. So this would become the standard. The reason for that is there are a myriad of city ordinances across the state of Tennessee. Some have no standard, just fill in the hole. Some 10%, some 100%. The standard seems to be the majority of cities use 200%. So that's what we're going to go with because most cities are doing that. And with that, I stand for any questions.
Thank you for that explanation. Do we have any questions? Speaker Marsh, you're recognized.
Thank you, Mr. Chairman. And the way this was explained to me, this was investor-owned gas companies. Is it more than that?
We have several gas companies in Tennessee that have this same issue. There's one in my area. I know there's one in Nashville. These are investor-owned companies that provide that utility to the area in which they're located.
You recognize, Speaker Marsh.
Would it also apply to like water lines and anybody cutting roads, or is it just mainly gas companies?
I believe it would apply to all, but I can't speak directly to that. You might ask legal.
Members, we're going to go out of session and hear from legal services. State your name for the record, please.
Levin Middleton, Office of Legal Services. The statute that this is going under pertains specifically to gas companies. So I don't believe it applies to others.
Any other questions while we're out of session for the attorney? Okay. Members, we are back in session, and I believe I had Representative Burkhart is up next.
Thank you. I think I'm kind of going where the previous speaker went. I think I would love this bill more if it would apply to every cut and not just a private gas company. I think maybe water lines and whether it's utilities or city utilities. I think maybe if we all got uniform, I think that's part of the confusion sometimes is this one's got one rule, this one has another one. I think we get more uniform and make it apply to all utility cuts. I think it would be a whole lot more useful bill and I appreciate you bringing this bill because it's a great bill. And maybe we could piggyback with that and try to get it all tied together. So anyway, I appreciate it. Thank you.
I can't disagree. Since it only applies to gas companies, I would assume that the local municipalities would have the authority to continue to pass ordinances related to those other utilities. But certainly willing to look at another bill covering all the utilities in the next session.
Chairman Vaughn, you recognize.
Thank you, Mr. Chairman. And I was going to offer to my colleagues, I'm going to make sure the caption can hold it, but that is my intent to bring an amendment prior to full committee that it will deal with street cuts in general, not just those that are designated for natural gas. The other issue that I want to bring out though too is that a part of that amendment that I'm planning will be to put a time limit on it, because I know that I grow weary of driving over steel plates that may be in place for months at a time. I know that I've got to figure out the wording, how to do that, so make sure that the asphalt plants are available, but there's no reason that folks should be dodging steel plates. Let's get this issue under control to where it's good for the cities and towns and their citizens because they know that the repair will be soon. And then at the same time, we won't be looking at a repaving project on the back of a utility company. So that's the direction that I'd like to take. Chairman Howell's great idea.
Chairman Clemens, you recognize.
Thank you, Mr. Chairman. And I guess this would be to my good friend, the chairman of the full committee. with regard to an amendment. I don't see any protections in here, whether, if the rest of the pavement or sidewalk, the integrity of that is threatened or jeopardized in any way, that would require them to fix that, as well. That's my sole concern. I understand the purpose of legislation. I would love to see if there's a threat to the integrity of that it be. And my question is, when we're talking about 200% of the surface area, so we've had my neighborhood just chopped all up with these ditch witches. It's about a 2-inch cut. So does that mean they just have to put a 4-inch thing there on top of it? I mean, I know we're probably thinking in bigger terms, but there are, when they come and slice up the roadway and threaten the integrity or compromise integrity to some extent of sidewalks in that regard.
Chairman, you recognize.
My assumption would be that if it is a gas line, that would be correct. If it's another utility, that would fall to the local ordinance.
Chairman Clemens, you got anything else?
No, that's it, Mr. Chairman.
Okay. Members, Chairman Vaughn, you recognize.
I was going to tell my good friend from Davidson County that we will add some language in there that if pavement is alligator, well, if there's cracks in it, then that they've got to make the full repair, even if it exceeds the 200 as a result of the work of that utility. But we'll get a deal where I think everybody will be happy with it in the end.
Chairman Howe?
I think that would be considered a friendly amendment. And in talking to the people who represent the utilities, their intent is to restore it back to its original position that it was cut in.
And I will tell you, Chairman Howe, I spoke to several utilities from around the state, and this is a much needed piece of legislation. There's no consistency whatsoever, and I'm very excited. We love friendly amendments, and Chairman Vaughn's a very friendly chairman. So I look forward to this bill being amended in full committee to include all utilities. Members, if we have no further questions for the sponsor, we are voting to send House Bill 2300 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Sir, we'll see you next week in full commerce.
Thank you, Chairman and Committee.
Members, that brings us to item number 6. That's House Bill 2440 by Representative Sparks. We have a motion, we have a second, and Representative Sparks, looks like you've got an amendment.
Yes, we talked about this earlier.
What's your drafting code on that?
Well, we hadn't had it filed yet. We sent it to legal. Oh, you're talking, okay.
What is drafting
We
code?
talked about the other amendment that you were asking.
Okay, yeah, the one that you did timely file, 14744.
Yes.
You do want that one put on there?
Yes, please.
Okay,
Yes.
we have a motion, we have a second on that amendment. Do you want to explain it, or is it basically the bill?
It's basically the bill, sir.
Let's put it on there. Members, we're voting to put amendment 14744 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, we're back on your bill as
Yes.
amended, and we will let you explain it.
Yes, thank you. At present, most professional licenses can be placed in inactive status, members, by paying or continuing to pay nominal fees until which time the license is reactivated. If one of those fees is missed, however, the licensee must start all over in the process of the licensure. This bill would allow citizens licenses initially in good standing to pay back the fees plus any penalties to help reinstate their license. This came from some constituents back home, and it basically is it's pretty important where folks during the COVID confusion and some of the problems this had happened to them. I think it's a good pro-business piece of legislation that could help some folks back home. I haven't had any opposition to it other than your concerns about extending the life of continuing education. They still have to do their continuing education and pay those fees and take those courses.
Members, do we have any questions? You've heard his explanation, and I do want you to clarify, and I think you just did,
Yes.
that this being able to pay that and get it reinstated, there would be an expectation that they were up to date on their continuing ed.
Yes, sir. Correct.
Okay. Chairman Vaughn, you recognize.
Thank you. Representative Sparks, is there a length of time that's basically this opportunity window sunsets? Because is it 10 years, 20 years? Because I'll tell you why.
Yes.
I got caught in this one time and I had to take the dadgum licensing test over again. And that is that's a challenge for a person with my limited intellect. So, but at the same time, I understand that to be, that was over about I forget how short because of, long story, but regardless. But I do think though, that if you look at a time period on the back end of it, different laws have come into play, different things happened during that time period. And I would be concerned if we didn't have a backstop with regards to the years on,
Yes, sir.
on that bill. So if we contemplate the CEU, I think we probably need to say that this limits it to a cutoff point between 0 and maybe 5 years or something. But that's just a suggestion.
Yes, sir.
That sounds like another friendly amendment in full
Yes.
commerce.
And a friendly committee.
All right.
Hopefully.
Members, you've heard the explanation. Do we have any other questions for the sponsor? If not, members, we're voting to send House Bill 2440 as amended to full commerce. All in favor, say aye.
Aye.
All opposed, say no. The ayes have it. So we'll see you in full
Thank you, Chairman.
commerce.
Thank you, committee.
All right, members, that brings us on the calendar to item number 7. And that's House Bill 2026 by Representative Martin. And Representative Martin, do we have a motion and a second? We have a motion. We have a second on this bill. Representative Martin, you're recognized.
Thank you, Chairman and committee. I spent 25 years in the cemetery business. Before I got in real estate, I tell people I went from inches to acres, from boxes in plots to houses on lots. And so I have an experience with it and have been with thousands of families at their time of grief and found that at that time, so often when people bury a husband and they come back 40, 50 years later to put mom next to dad, they're shocked at the price of what the opening and closing of the grave would be. And so this was legislation that would help the consumer to have the opportunity to purchase that opening and closing when they purchase that grave. I don't know anything that you purchase today, but you can't use it until you purchase something else down the road. But nevertheless, I've gotten a weather report and it's not sunny. It's kind of cool, breezy. And so I feel like MacArthur on June 5th and I'm waiting on June 6th. And so there'll be another time and another day. And with that, Mr. Chairman, I don't want to take any more of your time. I would ask that we would take this off notice.
Members, you've heard the, well, at your request, House Bill 2026 is taken off notice and back to the clerk's desk. Members, that brings us back to item number 1. That's House Bill 2479 by Leader Cochran. We have a motion. We have a second. Leader, you are recognized on your bill, and I don't see any amendments, so go ahead.
That's great. Thank you, Mr. Chairman, and thank you, committee. The highlight of this bill says if an issue does not fall into the bounds of federal commerce laws, which is the Interstate Commerce Clause, it's Tennessee's purview to regulate those goods that are sourced, created, sold, and utilized in Tennessee. So essentially those items that do not cross state lines. We're just clarifying that it's the state government that regulates those.
Thank you for that explanation. Members, do we have any questions for the sponsor, Representative Thompson?
Thank you, Mr. Chairman. How does this change? I mean, I thought all this was already laid out pretty much in federal law. Can you tell me what might be different from federal regulations regarding interstate commerce?
Leader, you recognized.
Thank you, Chairman. Yes, and I would argue the same, that the Constitution, I believe, makes this pretty clear. So I agree with you at that point. This is just making it clear, I think, in Tennessee code, that if it's a product that doesn't leave state lines, that it is regulated by the state of Tennessee. I think just making that clear in our own code. But I would agree with you. I think the federal Constitution, 10th and 9th Amendments are pretty clear on that.
Okay. Members, Chairman Vaughn, you recognize.
Thank you. Leader Cochran, could you give me an example of this? Because I'm thinking, okay, if I cut hay on my farm and I sell it to my neighbor, but then it seems like we're creating a little bit of murkiness here in the fact that if I sell hay on my farm to my neighbor across the road for his cows, then that's obviously an intrastate transaction. But if I sell it to some folks down in Walnut, Mississippi, then it becomes an interstate. Does this lead to duplication? I'm trying to figure out. It seems as if it would be, if we've already got it figured out why we need this, why do we need this legislation, in your opinion?
Sure. Leader?
Thank you, Chairman. And Chairman Vaughn, I think one area in particular that it could add some additional clarity would be areas of meat inspection, where you basically would have an option. And so we saw that issue come up somewhat during the pandemic, and where there's a very short supply of federal meat inspectors, of actual USDA meat inspections. So and those, they inspect those meat products that are crossing state lines. We didn't have really a mechanism in place at the time, but until last year, where we passed a state meat inspection program where we could hire our own meat inspectors. We just didn't have that program set up at the time. And so so let's say if you had another situation like that where you were having locally sourced, so grown beef cattle, they are butchered locally and sold locally. You could have a wider availability of meat inspectors because there's so few USDA inspectors. That was a difficulty for our butcher shop. So if you had Tennessee state inspections as well, if that's something that we decided to offer, again, you could have those local markets of beef and again, create a larger market for them because you would have inspectors. You wouldn't have to wait on that USDA inspection.
Chairman Vaughn?
Thank you, Mr. Chairman. I look forward to learning more about this.
Sure.
I guess that's that's about as excited about it as I can get, but I look forward to learning more.
Sure. Representative Hale, you recognize.
Thank you, Chairman. Leader Cochran. So if I'm understanding this right, we have a lot of dairy farms now that process, do their own and create milk, ice cream and stuff. So as long as that's kept right here in the state of Tennessee, that's what this bill would address, right?
Leader?
Thank you, Chairman. Representative, that is correct. It's clarifying that those products that do not cross state lines, that it's the state's purview to be clear, it's not saying that things will not be regulated. It's just saying that it's the state of Tennessee that will take responsibility of that, not the federal government.
Okay.
Representative Hale. Chairman Zachary.
Thank you, Mr. Chairman. Leader, thanks for bringing the bill. I think you made a really good point related to the meatpacking industry. There are certain limitations within the federal government that inhibit their ability to meet the needs of Tennesseans. And so if we pass this bill, we're ensuring that we can take the steps, as Representative Hale mentioned, as you mentioned, to make sure there are aspects within our economy that continue to move forward. And we simply reinforce, as you said, what's in the 9th and 10th Amendment. So thanks for bringing the bill.
Thank you.
Chairman Clemens.
Thank you, Mr. Chairman. So under your hypothetical with regard to meat inspection, and you said if this goes into effect, and then you said if the state of Tennessee decided to inspect those, it would be up to the state of Tennessee. Well, my concern is if we pass this bill before the state of Tennessee decides to take that action, there's going to be a gap in time there or an infinite amount of time where the state doesn't act. Therefore, we have meat being consumed and sold across the state of Tennessee with no inspection whatsoever. Are you not concerned about the health risk?
Leader Cochran.
Thank you, Chairman. So you have meat inspection in place currently with USDA inspection, and you have ways that you can sell meat currently, I think, without that USDA inspection. This is just making clear that if Tennessee decides to offer that program, which I would remind the committee that we actually did approve that as a General Assembly last year to have state meat inspection. So that mechanism is in place, and so this is just reinforcing really a step that we've already taken. It's just to clarify that we have the authority to operate and manage that program and others, right? Others that would involve items that are just contained in this state.
Chairman Clemens, you got anything else?
Well, I would just clarify. I mean, we've passed laws to allow, the taking so if I raise a cow, I can bleed the cow and I can take it to the meat locker and feed my family or, give it to people. That's what we allow. I mean, I can't raise cattle over in Ducktown and put it in a car with no refrigeration or requirement to drive it all the way across the state to Memphis because refrigeration, those types of things are required under federal regulation and federal law, and then sell it in Memphis. We don't know what happened in the meantime. That meat's probably spoiled, but under this, those USDA regulations wouldn't apply, and Tennessee law wouldn't necessarily apply. So, and this obviously isn't just limited to meat, but other things.
Sure.
So I guess my concerns regard the health risks that would be associated with this. Thank you, Mr. Chairman.
Chairman Leader Cocker, you got anything on that?
Nothing further.
Members, any other questions for the sponsor? If not, we are voting to send House Bill 2479 to full commerce. All in favor say aye. All opposed say no. The ayes have it. Sir, we'll see you next week in
Thank you,
full
Chairman and committee.
commerce.
Thank you.
All right, members. Item number 9, House Bill 1859 by Representative Davis. We have a motion, we have a second, and Representative Davis, I do see an amendment. Yeah, go ahead. What?
Make sure I've got the. Thank you, Chairman. So I have amendment code 014679.
We do
okay.
not
So
stand by a
it's
minute,
the-
members. We
right.
don't have that amendment drafting code.
So is it 015308?
That's the one I'm showing.
There we go. Bingo.
Got a motion. We have a second, and let's go ahead and put that amendment on there, guys. We're voting to put amendment drafting code 15308 on the bill. All in favor say aye. All opposed say no. The ayes have it. Representative Davis, you are recognized on your bill as amended.
Thank you, Chairman, and thank you, committee. And so this amendment actually makes the bill. When back in like 2018, we passed what's called the Fresh Start Act. And what the Fresh Start Act does is it allows for individuals to apply for some sort of licensure. And if they have a criminal record, that they're not automatically denied that application. The licensing agency reviews it, has the discretion to determine whether or not they approve the license, approve it conditionally, or deny it. And so what we're wanting to accomplish with this piece of legislation is in the Fresh Start Act that was passed, there were some exclusions. There were certain professions that were excluded from the application of the Fresh Start Act. One of those had to do with mental health and alcohol and substance abuse. And so what we're trying to do with this piece of legislation is kind of in two parts. We're pulling from that exclusionary list the mental health services and alcohol and drug abuse prevention and treatment. And then under their section entitled in code, we're going to apply the Fresh Start Act to those individuals that are wanting to apply for that application. Then also with respect to this, it does change that if they are denied an application, that vague terms aren't used, that it's clear to that applicant what the denial is. So some of those terms include good moral character or character and fitness, because we want to make sure that individuals understand if they have an ability to reapply and to work towards a goal, that they clearly know what the steps are that they can, that are a barrier to their current licensure, that they can actually improve upon that. And so with that, I'm ready for any questions, and I would appreciate your support.
Members, you have heard the explanation from the sponsor. Do we have any questions? And I saw you had someone on here to testify. Do you want to testify, or just if we need
She's
it?
flown here to testify. I would love to have Megan testify if that's.
Let's
if
go
the
out of
committee's
session real
amenable.
quick. And members, we're out of session. I'd like to invite Megan Forbes up. And Megan, if you'll just make sure that your microphone is on and state your name for the record. And she has how long, Jackson? 3 minutes.
Can you hear me okay?
We got you. Go ahead.
Thank you, Mr. Chairman, and members of the subcommittee. My name is Megan Forbes. I'm Senior Legislative Counsel at the Institute for Justice. We're a nonprofit public interest law firm that works to protect civil liberties. And we've also extensively researched the licensing burdens for people with criminal records across the country and for lower income workers. We're here in support of this bill because we think it will make a big difference for returning citizens to be able to access jobs and opportunities in the state. Several years ago, when Tennessee enacted the Fresh Start Act, it was a big step in the right direction. And even though this was a big step forward, some licensing barriers remain. Today, agencies and boards can still use vague and arbitrary character standards to deny people, which can lead to people being arbitrarily excluded from jobs. And this is something that 21 states now prohibit. And then as it relates to licenses for drug, alcohol, and mental health counselors being excluded, these are jobs that we see people in other states with criminal records work in successfully and also share their lived experiences when they enter into these occupations. These reforms are good for returning citizens and good for the state. They help address workforce shortages, and research shows that states with higher licensing burdens also have higher rates of recidivism. We appreciate your support, and I'm happy to answer any questions the subcommittee may have.
Members, you've heard from Ms. Forbes. Do we have any questions for Ms. Forbes? If not, thank you so much. We appreciate you coming all the way in to testify on that. And members, we're going back into session. And we are back on the bill. Representative Davis, do you have anything else? Members, any questions? If not, let's get this thing moved out here. Members, we're voting on House Bill 1859 to send it to full commerce as amended. All in favor say aye. All opposed say no. The ayes have it. Congratulations. We'll see you next week in full commerce.
Thank you.
Next up is item number 10, House Bill 1731 by Representative McCallum. We have a motion. We have a second. And Representative McCallum, you have been waiting patiently, so we anticipate getting to this and are excited about it. And I do show an amendment. What drafting code do you have?
Thank you, Mr. Chairman. It is Amendment Code 015542.
That's what I'm showing as well. Can I get we have a motion. We have a second on the amendment. Do you want to explain it or go ahead and put it on the bill?
It makes the bill, sir.
Okay. Members, we're voting to put Amendment 15542 on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, we're back on your bills amended, and you're recognized for explanation.
Thank you, Mr. Chairman. Members, what this does is create the Motion Act, which stands for the Modernization of Towing, Immobilization, and Oversight Normalization. That's a mouthful. Currently, towing, parking, and booting regulations in the law are in various sections and utilize different and sometimes inconsistent definitions. The bill deletes all existing language throughout the code and adds all the provisions into new one consistent chapter. And it divides the key changes into 2 points, which are booting and towing. Under the booting section, booting will only be allowed in local jurisdictions that have adopted by ordinance the state booting law. Booting will only be allowed on vehicles that are unattended, immobile, curbsiding, or violating parking restrictions on commercial lots, including commercial garages. Booting will not be allowed on streets, public lots, public areas, or non-licensed commercial lots and garages. Furthermore, booting will be allowed by law enforcement to take into custody a motor vehicle found to be immobile, abandoned, unattended, or used in curb stoning. 48-hour notice is going to be required on that one, or on public or private property. In general, booting will be prohibited other than on a licensed commercial lot by a licensed employee. The licensed employee must be dressed in a way that can easily identify the individual as an employee of the parking lot owner and must display photo identification to indicate they have authority to boot or tow vehicles on said lot. Notice provisions have to be added to ensure consumers are aware that parking in the lot without paying could result in their vehicle being booted or towed, and it requires signage to be posted at each parking space if the space is subject to being booted or towed. Notice also has to be placed on the windshield of a vehicle that has been booted, notifying the driver that boot has been attached and that moving the vehicle could cause damage. Additionally, no booting will be allowed on a vehicle that has been assigned a visible U.S. Department of Transportation number with a license plate pursuant to TCA 55-4-1139, and or a trailer that has a similar license plate attached. This is to prohibit interference with interstate commerce and to be in compliance with the Federal Motor Carrier Safety Administration hourly rules of service for drivers. A boot has to be removed within 30 minutes of contacting the commercial parking lot. Commercial lots are prohibited from charging more than $75 to remove a boot from a vehicle and are required to take cash, and in addition, they have to take credit and debit cards as a method of payment. All the above fall under the protection of the enforcement of the Tennessee Consumer Protection Act that's subject and enforcement by the Attorney General. With regards to towing, all towing laws will be consolidated into Title 55. Notice that a vehicle's been towed is not changed other than registered mail is deleted. It now allows for all federally recognized delivery services, UPS, FedEx, including the post office as well. Vehicle cannot be towed unless unattended for 12 hours. Additionally, towing companies are now required to immediately release a motor vehicle that a towing operator has begun to tow but has not yet been removed from the parking lot if the owner arrives and pays a vehicle release fee of up to $100. Also directs the Department of Revenue to create a motor vehicle portal, which will be accessible by law enforcement, towing companies, vehicle owners, lien holders, etc. A fee will be charged to all users, including law enforcement, to cover the cost to establish the portal. Portal will be used for all public notifications of the sale of unclaimed vehicles, and as anticipated, the motor vehicle information will be entered into the portal the day that the notice is sent. Towing and storage fees will now be tied to the local highway patrol schedules in each specific highway patrol district. And lastly, the Tennessee Attorney General and reporter has all the investigative and enforcement authority under the Tennessee Consumer Protection Act to institute any proceedings in circuit or chancery court. And with that very long explanation, I renew my motion.
Members, you have heard that very thorough and long explanation there. Do we have any questions for the sponsor? Chairman Clemens, you're recognized.
Oh, I was going to ask him to reread the bill, but never mind.
Those were the cliff notes.
So my question is this: if I'm a parking lot owner, which I wish to God I was, and I've got a car sitting there, and so space is money in the parking lot business. What is the process for me to get that car off my lot? What are my limitations?
So essentially, you could still have a vehicle towed. You could still put a boot on the car. It just has to be an employee of that lot. You can't contract with somebody and pay him a commission to go and boot instances. And this really stemmed out of kind of two circumstances, one in Memphis, one here in Davidson. The Davidson was an event where the gentleman was out to dinner, came out, he was expired by 10 minutes. Nobody had booted his car. He paid to extend his time on the parking, goes back in, finishes his dinner. A week later, he's back in the same parking lot, finishes dinner, goes out, still has time on the clock, but the company booted him. When he called to remove it, he says, what's the deal? Why'd you put it on? He says, well, we didn't get you last week, so I figured we'd get you today. And in Memphis, it had to do with in particular with the U.S. Department of Transportation trucks and whatnot, where a driver would park for 3 minutes to go inside and grab a Coke, come back out, and there was a boot, and they refused to. They were going to charge an exorbitant amount, and then they ended up towing the truck, and we were going to charge the company $15,000 to get it out of their lot. So for a commercial lot, back to your point about parking spaces, you could still do it. It just has to be your employee that is clearly identified, that is installing the boot on the vehicle.
Chairman Vaughn, you recognized.
But does your bill preclude a parking lot owner from hiring a tow company to come get it, because that wouldn't be an employee of the lot?
Sponsor, you recognize.
No, sir, it shouldn't require it. It would preclude them from being able to contract with the tow company to boot them. But as far as towing, they could still hire a tow company to come tow it.
Chairman Vaughn. Speaker Marsh, you recognize.
Thank you, Mr. Chairman. And in the trucking business, we've had all kind of problems in Shelby County with many trucks being booted daily. It was just gotten to be a racket down there. And it was one company that was just notorious for booting everybody, and they couldn't get him to stop. So I'm proud you brought this legislation.
Members, any other questions? Representative McCallum, it sounds like a great bill and a pretty comprehensive one. So
thank you.
Appreciate you bringing it. Members, we are voting to send House Bill 1731 as amended to full commerce. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is on its way to full commerce.
Thank you, Chairman of Committee.
Members, next up is item number 11 by Representative Barrett. Okay, he's presenting in another committee, so we're going to move on here to item number 14. Representative Miller is also absent. Representative Hardaway. Okay, we will roll item number 15, House Bill 351 to the Hill. I believe Representative Alexander is out there running some bills as well. That brings us to Representative Burkhart. Item number 22, you're recognized.
Yeah, I'm going to take that off notice.
Okay, without objection, House Bill 2530 is off notice. Now that brings us to item number 23. That's House Bill 34 by Representative Thompson. Do we have a motion in a second? We have a motion. We have a second. Okay, we do have a second for Representative Thompson. And I don't see any amendments on this one, Representative Thompson, but we do have some people to testify. But you're recognized if you want to say anything on your bill.
Yeah, this is simply to add, well, right now, there's only one county in the state, Nashville-Davidson County, that has a rental registry. And this would simply add Shelby County onto this bill. And at this point, I'm happy to have the individuals testifying to come up.
Okay, members, we're going to go out of session. And we're going to hear from Pablo Pereira. And are y'all all coming up at the same time, or are y'all okay, we'll go ahead and hear from you. And if you don't mind, just make sure the microphone is on and state your name wherever you'd like to. You could sit or stand, either one. And just state your name for the record. And you have 3 minutes. Make sure the red light's on.
All right, so can you hear me now? Thank you, Chairman, and thank you to the subcommittee for allowing me to be here. My name is Pablo Pereira. I am a principal real estate broker at Memphis. I manage 17 people, and between my agents, they probably sold over 100 properties last year. Shelby County has become a wonderful place to live and a wonderful place to invest. And I'm asking the committee to consider opposing this bill because really this is a Trojan horse. Let me expand on that. Right now, people are coming from overregulated states like California, and they're escaping this regulation. Having this amendment changes and immediately puts a burden on businesses trying to do business in Shelby County. Right now, what makes a great, attractive investment is people buying a property. They're using local labor, they're paying local materials, and they're paying local taxes to create affordable housing in Shelby County. By having this amendment pass through, what this does is makes Shelby County a less attractive place to come and invest. There has never been provided to us any sort of study that's ever been done on how this fights blight. Passing this Trojan horse allows other things to change. Today, it's a $10 money grab per landlord. Tomorrow, this will be $150 to $200 per door per landlord. Under the premise of we know who these people are, they're buying these properties. But here's the thing. We already know the ownership because that is public record. Tax authorities know where the owners live. We need to make Memphis and we need to make Shelby County a great place to invest. And under the premise of this amendment, it is creating more regulation. It is a complete money grab and is not welcome in the real estate community. Thank you for your time.
Thank you for your testimony, sir. Do we have any questions for Pablo? If Representative Thompson, go ahead.
First of all, can I go? I know this is out of
Speaking to the
order,
microphone, please.
This is out of order, but I would like to recognize Mr. Pereira, who was a constituent until redistricting, and we've had very good conversations and usually agree on things too.
Yes, sir.
Now I do have a question for Mr. Pereira. Are you familiar with Davidson County's model? Have there been problems like you described with Davidson County, since they have had this for several years now?
Thank you, Representative. Davidson model is $10 per landlord. In Shelby County, let's say we have 2,700 landlords. That's going to be $27,000 for somebody to manage 160,000 rental properties. It's only a matter of time for this Trojan horse to become another money grab that you can run this on $10 per landlord. And what comes next is 100, 200, or what's the limit? It didn't work for Davidson County. I don't know why it's going to work for Shelby County. And we don't have any research that rental registration will work in any county for any research against blight.
Representative Thompson, you got anything else?
Not right now.
Okay. Speaker Marsh, you recognized.
Thank you, Mr. Chairman. And so this charge is for rental houses, the way I understand it, correct?
What this is asking, this bill is changing to single out Shelby County to be part, or taking away the word metropolitan area, which would include Shelby County now to be part of the new proposed rental registrations. They're going to be coming in the near future.
Okay, Speaker, go ahead.
I guess my question is, if they're rental, if it's a rental property, how is the city going to know if it's rental or if it's occupied by its owner in full time? So it looks like to me that rental people are not going to pay this because they're not going to be known to be renters. So I don't know how it's going to work. I don't know how the paperwork will work on all this.
Any other questions for Mr. Pereira? If not, appreciate your testimony today. And we do have Mr. Joe Kirkland up that wanted to testify. And Mr. Kirkland, when you just make sure your red light is on for the microphone and state your name for the record. And we got you going for 3 minutes.
Is my light on, Mr. Chair? I mean,
It sounds like it is, yeah.
Okay, thank you. I want to thank you very much for allowing me to be here today. My name is Joseph Kirkland. I'm from Memphis, Tennessee. I am currently the Vice President of the Memphis Investors Group, and I'm an attorney in private practice of law and have been for 48 years. Memphis Investors Group is a group that tries to train investors on how to be proper, ethical, good landlords, housing providers. I want to thank the chair and the committee for allowing me to be here today. The bill will extend the property registration ordinance or the property registration law that currently applies to Nashville to Memphis and Shelby County. This is supposedly and has been represented as a way to affect blight, to end blight. This will not have any effect on blight. I'm going to give you my name and my address and my telephone number, and that's going to end blight. It's not going to happen. And if there's a wrong actor out there who the city maintains they cannot find, they're not going to register. If I'm a slumlord, why am I going to register? As Mr. Pereira mentioned earlier, there has never been any empirical study that can show the effect on blight of a property registration ordinance. And we've talked to the Director of Public Works, who I'm sure you'll hear from in just a second. He has indicated that, well, the best practice is that this be done. There's no best practice manual for cities and blight. There is no study that's been done. So we would suggest that that's just not necessary. The city has gone on and has drafted, they haven't passed, but they've drafted ordinances for inspections of rental properties. They're going to want to, and what's coming next is an ordinance that's going to require a property inspection of every one of the 134,000 rental units in the city of Memphis at a charge for whatever a home inspector would charge before you can put a tenant in your property. I would suggest there's 134,000 rental units in Shelby County, and folks seem to be getting along pretty good. Now, the representative who I have met with and talked to and even attempted to cajole on some of these items has indicated that this is a good thing. But I would submit that the authority thought is just the tip of the iceberg. It's going to allow the camel's nose under the tent for further regulation to make us look like California, as Mr. Pereira said. Thank you very much, and I would ask that you please oppose this bill.
Thank you, Mr. Kirkland. Appreciate you coming to talk with us today. Members, do we have any questions for Mr. Kirkland? Representative Thompson.
Thank you, Mr. Chairman. Mr. Kirkland, and I appreciate our conversations too, and I appreciate having known you for many years. But I wanted to ask you, Davidson County has had this for going on 2 decades. How is this increased regulation? What problems have come with Davidson County by having this
I'm glad you
program?
asked that, Representative, and I thank you very much for the question. I think that you'll find that Davidson County just takes the check, strips it off the form, puts it in the bank, and puts the form in a box. Davidson County, how they treat it has never been presented to me. I have written Davidson County to ask them. They have not replied. They do not maintain an ongoing database of landlords, which is what I think is anticipated. And I don't know how you're going to track 134,000 properties for $10 per landlord, which according to the fiscal note is going to bring in $27,000.
Representative Thompson.
Yeah, I have talked to Davidson County. I have talked to the department that actually controls this and has enforces the registry. And yes, they do have a database. They have changed this to come along with modern technology, and they found that this is actually work very smoothly, that they have a minimum of complaints, and it's far from when you consider the budgets of these of the larger counties, any revenue brought in is simply to take care of the cost of the administrative costs, and it has by far not been a money grab or a windfall of funds.
All right. If there's no further questions for Mr. Kirkland, we appreciate you coming to talk today. And we do have a couple more folks. We have Miss Erica Sugarman. Yeah, if you'll. Robert Connect. Absolutely. Yeah. Are you, if y'all are together, you can both have a seat and both, yeah. And so just make sure that your microphone is on. You'll see a red light. State your name for the record, and you are limited to 3 minutes. Go ahead, Robert. You're recognized.
Yeah, Robert Connect. I'm the Public Works Director for the City of Memphis. Do you want to introduce yourself?
Yes, Shelby County Commissioner. Go ahead.
I've been the Public Works Director for almost 12 years, over a decade, and one of my responsibilities is also the housing and the Code Enforcement Director. So I guess the justification that we're talking about is just the sheer complexity of managing a large housing stock. In Memphis, there's 245,841 parcels of individual properties. Of those, 189,000, a little over 189,000 are residential properties. And of those, 120,000 are potential rental properties. So you're looking at 60% of our residential market is rental properties. And for a city, any city, that's a huge task to kind of understand and manage the difficulties with ownership where they don't want to manage a property effectively. And so people have to live next door to properties where they are not taking care of it. And it becomes what we call blighted property. And so a city's then tasked with trying to bring their property in compliance, which means we have to bring in the owner and the tenant and try to resolve the matter so that it doesn't look in that condition. Sometimes it's easy because the owner's local, but the vast majority of our property ownership has changed dynamically in the last decade by investor-owned properties, LLCs. They are by far the largest group of investors, and they're all over the world. And you try to locate somebody and get a timely response. This is all about getting a timely response from an owner So they will fix the problem. And if you can't find that person, or that if the registered agent from the state is not easily accessible, you're spending triple, quadruple the amount of time and resources just to get the property to cut the grass, to not let people park in the yard. This is what people see every day and they get so frustrated about. So yes, we're asking for a local registered person and part of the registry is a common practice by many large cities. There's no professor want to study this subject and do a scholarly subject. So you look at what is best practice, and these are best practices to have a registry program. We're not talking about inspections. Inspections are only necessary if the property remains out of compliance. But I mean, we're not even going that far. We're just asking for just a local agent who can be timely communicated with so that we can resolve the condition of the property. That's the main goal of this type of requirement.
Okay, point of information. Was that 3 minutes?
Will you state your
each?
name for the record,
Thank
please?
you. Yes, Erica Sugarman, Shelby County Commissioner. And point of information. Okay, was that 3 minutes each or is that together?
I can give you 3 minutes each if you,
Thank you, sir.
if you're talking as a couple, you can share that. Yeah. And so, Robert, are you finished, or do you still have about 30 seconds left? If you have anything to say.
I only say that, just like I said, consider myself a subject matter expert on this, having done it for a decade. Talked to lots of cities who do this kind of work. And that's why we also came up with these ideas. Now, obviously, when we first started talking and we did stakeholder engagement, we had a different model. But it was clear that it was best to kind of follow the Metro Davidson model. That's why we changed our plans. It's not a money grab. It's just simply best practice.
All right. Thank you so much for that. And then we have Councilwoman Sugarmont, if you have anything to add. Yeah.
Shelby County Commissioner.
Commissioner,
Yes,
I'm sorry.
sir.
I'm sorry.
And so thank you, Chair. And thank you, everybody, for allowing us to speak. And so I am a Shelby County Commissioner. And so as a commissioner, we're over 7 municipalities, including Memphis. And right now, Memphis is under siege from out-of-state investors, as you all stated before on record, mainly from New York and California, but also out of country. And so they hide behind these LLCs so we can not identify these landlords. Having said that, a year and a half ago, I became Shelby County Commissioner, first time elected. And I had an individual come to my town hall meeting, and he stated, "Please, Commissioner, I'm retired." He was an elderly man. He spent his life savings paying off his house. And so now he stated that he's being under siege. This is an unincorporated area. This is not just in Memphis. And he said, my block is filled with tenants, and the landlords will not maintain their property, and it's causing blight. And some of the people have contacted code enforcement, and they go to our environmental courts, and they're backlogged. And then they state, we don't have the resources to identify these landlords who hide behind these LLC. And so the other gentleman misspoke. We're not going to go out and investigate, good players like myself. I own rental property. I am a good landlord, but there are individuals who are not, good players. What's happening in Shelby County is also happening in Covington. It's also happening all over. I have to have family members in Knox County, around Davidson County, and I'm hearing the same complaints. All we want to do, the $10 will cover a registry. That's it. So we can identify these bad players. It's not going to impact people like me who own investment property. And this elderly man came to me and said, "Ms. Sugarman, Commissioner Sugarman, we're afraid to go out at night because these tenants are running havoc. They're inviting, I guess, a criminal element into our neighborhood. I cannot afford to go out and buy another house. I'm stuck in a nightmare." He said, "Under the Constitution, don't we have property rights? Shouldn't I be able to own my house and enjoy my years that I have left?" And this is the thing that's happening, not just in Shelby County, not just in Covington, not just in Knox County. Let all of us who want to have a registry, please allow us that opportunity. because what's happening in Shelby County also could happen in your communities. Thank you so much.
Commissioner, we appreciate you coming to talk with us today. And members, you've heard the testimony from from our Shelby County friends. Do we have any questions for them? Speaker Marsh, you recognized.
Thank you, Mr. Chairman. Again, I want to ask, like you said, you're a good actor and you'll probably sign up and pay. What about the bad actors? How are you going to find them to make them fill out the paperwork and pay the $10? Looks like to me the good people will do it, but the bad people are not going to change.
So every system you start off is going to have challenges. There are ways to start a process by utilizing, land records and sending official notices, but those all take time. There are ways to look at with some of the other actions or activities going on with like utilities trying to get better information about ownership as well, to kind of collaborate on that and gather that information so we have a database. But all databases are going to take time. We're not expecting this to happen immediately. Most cases we're talking once we would start an ordinance having 6 months to a year and giving a grace period that long to allow people to register. And a lot of public education and media would go into that.
All right, members, any other questions for the folks giving testimony? If not, members, we are going back in session. Thank you so much for coming all the way to Nashville to testify. And members, we do have a few people that have questions, I think, for Representative Thompson. I've got Chairman Zachary. You recognize.
Thank you, Mr. Chairman. Question on the bill.
Question has been called. Members, without objection, we are voting to send House Bill 34 to full commerce. All in favor say aye. All opposed say no. No. Noes have it. The bill fails. And Representative Thompson, we're actually going to, I know you were up next, but we've had a few people that have come across from the hall to run their bill. So we're going to hear from them and we'll come back to you here in just a moment. Oh, yeah. For what purpose, Chairman Clemens?
Just wanted to welcome a group. Leader Camper has joined us in here, and she has got a group with her from the Daughters of Zion, faith-based nonprofit from Memphis. They're serving youth in the community, and they're with their executive director and pastor, Gerald Kiner. So I wanted to welcome them today.
Welcome. Yeah, out of order. All right, members. Next up is item number 11 by Representative Barrett. That's House Bill 1067. We have a motion and we have a second. Representative Barrett, on your bill, you are recognized.
Thank you, Mr. Chairman. There is an amendment with this bill as well. If we could attach the amendment, that would be
what draft
preferable.
What drafting code are you showing on that?
I have 005178.
Okay, that's what I'm showing. Members, we're voting to put that amendment on the bill. All in favor say aye. All opposed say no. The ayes have it. Sir, your bill is amended. You recognize for explanation.
Thank you, Chairman Boyd, members of the committee. This bill deals with a roundup program on your electric or utility bills, wherein your bill gets rounded up to the nearest dollar, and those pennies go into a piggy bank somewhere that the utility keeps, and then they decide what to do with that money for charitable purposes. So the amendment is going to really kind of change the tone and tenor of the bill. And so what we're doing with the amendment, instead of forcing the utility companies to change how they're doing this business, we're just saying that they need to disclose what it is that they do with the money when they get it. And I do have a constituent that's here to testify, so I think the committee might want to hear that first, and then we can get into the meat of the bill.
All right, members, we're going to go out of session. And we're going to hear from Daryl Gillespie. Mr. Gillespie, if you'll just make sure that red light is on and state your name for the record, and you have 3 minutes.
Sure. Thank you, Mr.
Yes, sir.
Chairman, and thank you, representatives. I'm Daryl Gillespie, General Manager, CEO of Dixon Electric System, a municipal electric system that serves 40,000 customers in parts of 7 counties right here in Middle Tennessee. I'm here to support the amendment from Representative Barrett, and that in the transparency and consistency, I think that it would certainly give customers insight as to who the money goes to and how much money goes to those agencies and nonprofits and organizations, in that they would be much more informed as to what's going on with their dollars that participate in this type of program. I think back in 2019, Chairman Mr. Boyd put a really good set of guardrails in a piece of legislation that addressed the majority of the issues associated with Roundup programs. This is just a amendment that helps clarify and address some areas that weren't addressed in our original piece of legislation. And I would appreciate your support and consideration for that. And if you have any questions, I'd be glad to answer those.
Thank you, Mr. Gillespie. You came in under 1 minute. We appreciate that. Members, do we have any questions for Mr. Gillespie? If not, we thank you so much for coming, Mr. Gillespie. And then we also have, we're going to hear from Jeremy Elrod from the Tennessee Municipal Electric Power Association. Mr. Elrod, you know the drill. Make sure your light's on and state your name for the record.
Thank you, Mr. Chairman. Jeremy Elrod with the Tennessee Municipal Electric Power Association. And I just apologize to Representative Barrett. Just saw his amendment today, so I apologize for that. And we're comfortable with nearly all of it. We're local government entities, open government, open record, so we have no problem, sharing information about how we spend our dollars. There's, I would say, just two tweaks. I think perhaps two, or at least one, that I think can be addressed. Hopefully, is the utilities have to put together a report annually of how that money is spent, and one of the requirements in the legislation has to be sent to every customer. There are two types of opt-out programs, opt-in and opt-out, but particularly the opt-in programs have very low participation, only bring in a few $1,000s. If that could be tweaked so it can be just an electronic submission to customers, or it can be put on the website or something like that, that would save that cost to the utilities and to the Roundup programs. And then the second thing is that the amendment, correct me if I'm wrong, Mr. Chairman, if I'm speaking from memory, only applies to all municipal utilities, municipal electrics, and electric cooperatives. In the 2019 legislation, it also dealt with Roundup programs for all utilities. And so I think the bill just leaves out utility districts and private investor-owned utilities. So it'd be just two comments I would have. Otherwise, with absent those two tweaks, I'll meet with Representative Barrett some more and talk to my folks, but I think we can feel comfortable. I'm supporting at least the idea of it and just tweaking some language.
Members, do we have any questions for Mr. Elrod while he's here with us? If not, thank you.
And appreciate Representative Barrett working on it.
Thank you, Mr. Elrod. Members, we're going back into session. And Representative Barrett, did you have anything else you wanted to say on the bill? Or?
No, Chairman, just point out, I think what's important for the committee to understand is what we're talking about is not small amounts of money, particularly with the larger utilities. We're talking millions of dollars that's being dispersed through charitable organizations, and we don't know where it's going. So if you can imagine someone coming into your dresser every night and scooping the change that you take out of your pocket, and you wake up the next morning and it's gone, but you don't know where it's going and how it's being spent. I think it's fair for us to ask that there be some transparency, and certainly happy to work with Mr. Elrod and their organization to determine what vehicle is best for that transparency, whether it's a report that's mailed to their customer or if it's put on the website. How that's done is a small part of this issue, just making sure that there is some transparency and disclosure so that everybody knows exactly how that money's being spent.
All right. And I did have Representative Thompson on the list. Go ahead.
Thank you, Mr. Chairman. What specific problems have you seen right now with any of the opt-out programs in Tennessee?
Spot you recognize.
Well, specific problems in what way? I mean, the only problem I'm trying to address with this amendment, Representative Thompson, is just the fact that the customer that's having their money taken and used for a charitable purpose doesn't have any input as to how that's used and they don't have any knowledge. They're not being disclosed as to how that money's being used. That's the main issue that I'm dealing with.
I'm just afraid that we're getting a bit too bureaucratic by having to send information into bureaucrats with the state versus allowing the local governments, the local utilities to should be able to handle this themselves.
So
Sponsor, you
public,
recognized.
public utilities use public dollars, so they're already subject to public regulation and oversight. And this is no different. The difference is, though, is they're taking public dollars, public pennies that add up to millions of dollars, and there is no disclosure to the public as to what they're doing with that. So, for instance, you may be okay with your Memphis Light, Gas, and Water making donations to Planned Parenthood. Some of your constituents may not be okay with that. So how that money's being spent needs to be disclosed to the consumers so that they can make an informed decision as to whether or not they want to remain in the program or opt out. There's no decisions being made right now to opt in or out with knowledge and understanding of how that money's being spent because it's not being disclosed by the utilities.
Representative Thompson.
Just for the record, MLG&W does not contribute to Planned Parenthood. They provide the funding for weatherization for low-income property owners in Shelby County, and the money is administered by MIFA, Memphis Interfaith Association, which is a long-term, well-respected charitable organization. So, no, we don't have any. We're not contributing to anything except to help our own citizens.
Sponsor, yes.
And Mr. Thompson, that's exactly what this money and these programs are for. It'd be great if that was disclosed on a website or disclosed in an annual report to the customer so that they knew exactly where that money was going.
Speaker Marsh, you recognized.
So in your legislation, you're not trying to change the opt-in or the opt-out, just leaving like it is now, because we dealt with that 4 or 5 years ago, and Chairman Boyd did an excellent job. We had a lot of discussion, and I think we got it worked out. And I think everybody is really happy with the way it's working now.
Sponsor.
Yes, sir. Gentleman from Bedford County. Chairman Boyd took some bullets and arrows over that, and I'm not interested in sending him back into that fight again. So this is all we're trying to do here. We're not changing the process or procedure for whether or not a customer opts in or opts out on the front end. We're just trying to make sure that the money is disclosed and how it's being spent.
Chairman Vaughn, you recognized.
We had talked about the issue with the mailing. That was when I originally got on here. It was because I think about the cost of mailing this to all the MLGW customers seems to be excessive. If we could put a notice for a website, that would be something that I think would be amenable to all, that if this legislation happened to move forward, that we would be looking for certainly some amendatory language as it moves forward.
And sponsor, let me say this, and you and I have talked about this. This actually covered 2 general assemblies that we were working on this, and it was actually my first bill, which is kind of like your first love, you know. You'll never forget. And so this was pretty comprehensive, and my wife is here, which is the one I really love. And you know,
good save. Good save.
You know, I do need to say this a minute ago. When the commissioner from Shelby County was talking, I kind of chuckled, and I wasn't laughing at her. I was thinking just how much fun my son is having back there. You know, just looks like he's really enjoying this today. But what I was going to say, sponsor, is going into this, you've been carrying this now for 2 years, and we thought you were taking a sledgehammer to the program. And so all of the stakeholders out there that were interested in this, that were involved when we put this together, they have come to me and said, surely we're not going to let this happen. And I said, absolutely not. You and I spoke at various times, and you mentioned some transparency. And I said, now I could dig some transparency on this, and if it's not already included in the original bill. And I will say this, and I remember talking to Mr. Gillespie about it, and we agreed. I said, listen, transparency, we can get behind. The challenge that we have now, because I didn't know you were doing transparency till this morning when we talked about it. The problem is we did not include water authorities or public utility districts in this, and we have to include them. We can't just go after electrical on this if we're going to do it. The other thing is that it's going to put a cost on the utility if they have to mail out a paper notification, where if they can do something digital, I think everybody can be happy about that. And so this is our last time meeting, and that's a little bit more substantial than something we normally do when we pass it on to full commerce. So I want to give you the option, and my commitment, and Mr. Gillespie, my commitment to you that we will work on this and we'll get this bill put together next year, because I believe that we will both come back next year, Mr. Barrett. I hope we do. And so I would like to ask, would you like to take this off notice and let us work on this and come up with something, just a rock star bill next year? Or do you want to, I don't know if there's a cool breeze blowing in here. I'm pretty comfortable, but at times it gets chilly. Or do you want to go out with your boots on? I mean, it's whatever you want to do here.
Well, Mr. Chairman, with Mr. Gillespie coming all this way from Dixon County, all 35 miles up here to see this bill presented, I'd love to get a vote on it. And with my commitment that before we come back to full committee, I'll work with Mr. Elrod. We'll make these changes that he's requesting. We can include the utilities that need to be included. And I think it's fair just to have a website or a link put on the bill that's sent out to everybody, so that even monthly, they'd see that link to know they can go see that report and see how that money's being spent. That would significantly reduce the cost to the utility companies. And I think those are minor changes. I know they're kind of big, but they're minor changes that we can make in a week and have an amendment ready to go whenever this comes to full committee.
Well, it's minor until the utility districts and the water authorities figure out that they're included in this. And so that's a bit more substantial than is customary for us to let slide under into full commerce. If you want to vote on it, we will give you one. I would caution the members of this committee that this is more substantial than it sounds, and I would encourage you to vote no on this. But members, without any further discussion, we are voting on House Bill 1067 as amended to send it to full commerce. All in favor say aye. All opposed say no. No. The bill fails.
Thank you.
But we'll
Mr.
work on
Chairman.
that next year, sponsor. Item number 12, we just learned died in Senate. So we will be taking that off of notice. Members, that's House Bill 2370 is off notice.
Thank you, Mr. Chairman.
Yeah, thank you, sponsor. We've got about 5 minutes left. Who do we need to take up? Is Miller here? Okay. Representative Miller, can you do this in 5 minutes?
I think I can do it in 5 minutes.
Okay,
or
we have
less,
a
Mr.
motion and we
Chairman.
have a second. Representative Miller.
Thank you, Mr. Chairman, members of the committee. I think it has an amendment.
What drafting code are you showing?
015297, which actually makes the,
Okay,
makes
we have
the bill.
we have a motion and seconding on the amendment. Let's go ahead and put it on the bill. All in favor of putting 15297 on the bill, say aye. All opposed say no. The ayes have it. Sir, you recognized on your bills amended.
Let me try to go through this, Mr. Chairman, as quick as I can. All contracts entered into between existing personal seat license holder of 10 years or more, a professional sports franchise for the purpose of a subsequent PSL with an upgraded or improved seating classification must include a provision that enables the PSL holder to purchase a subsequent PSL at a price not to exceed 20% more than the price that the PSL holder paid for the previous PSL. So that's the gist of the bill. Keep it in mind that this state has actually invested over $500 million into the new stadium. And so you have the PSL taxpayers and loyal fans, as if I'd like to call them. And having a PSL myself, which this is certainly has nothing to do personally, but to ask the team, what do you have the plans for in reference to rights of first refusal? Those individuals who currently has a PSL, and I've heard this, but I don't know this to be a fact, that for an example, if 20 years ago you paid $2,500, $3,500 for a seat, there's conversations out there that this new seats, again, right of refusal could be as high as $15,000. I don't know that to be the case, but I did have a meeting with some officials with the Tennessee Titans, and they couldn't tell me that that is true or not true, because in the configurations of this new stadium, I think it's going to be less seat, enclosure, et cetera, and all of the above. So I say those new seats will be quite expensive. And keeping in mind, again, right of first refusal. I did get some information from the standpoint that we have confirmed approximately 24% of the PSL holders are Nashville residents, okay? And that the remaining 76% of the PSL holders reside in the other areas throughout the state. Of that, Memphis accounts for the largest number of PSL holders among other three major cities. I did not know that. So we actually have a Tennessee team. So in essence, this bill is pretty much about giving the loyal Tennessee taxpayers, which happens to be PSL holders, some type of reasonable discount as we move further. Mr. Chairman, if I could yield, I did have a conversation with the chairman of this committee earlier this morning, and
Yeah,
yield for his comments.
Chairman Vaughn, you're recognized.
Yes, sir. Thank you, Mr. Chairman. And as a loyal Tennessee Titan fan and season ticket holder, I share some of my thoughts are similar to the dean of the Shelby County delegation. I hesitate to get into the Titans business, but I think that the message that I'd like to send would be is that this body has been good partners with that organization. Their loyal season ticket holders have been in good partnership with them through the years, and that we look forward anxiously to see what they're going to do to address particularly the lack of information that we're receiving on this as we move forward, because some of us will be contributing twice to the situation. But again, with that being said, though, I can't, although I have to give him a shout out for signing Tony Pollard, former Melrose University of Memphis State Tiger, to the backfield. So I'm really thrilled about that. But I can't support this bill moving forward because it does limit their business opportunities. But I do share many of the same concerns that I do with my friend, Representative Miller.
Thank you, Mr. Chairman. Speaker Marsh.
Thank you, Mr. Chairman. And Representative Miller, you met with the Titans.
Yes.
Did they agree with your bill?
No, they did not. No, they did not. I didn't expect them to agree with this bill.
Members, do we have any further questions or any comments? If not, members, we are voting.
Mr. Chairman.
Oh, yeah.
May I do the pleasure of actually withdrawing the bill at this point? We don't want to put
Representative
any
Miller.
pressure.
Would you like to take that bill off notice?
I'd like to take this.
He's taking it off notice, and it'll go to our special calendar, which we will deal with next Tuesday.
Thank you.
All right. Without
Thank you,
objection, members, House Bill 2646 is off notice and will subsequently be on our special calendar. Members, we are out of time for the day, so without objection, this meeting is adjourned.